Did you review the document
Ma'am,
entitled
hang on.
Court Certification of Defendant's
Ma'am,
Rights to
we're-
Appeal with your attorney? Did you understand it?
When me and him were on
Because
the,
this is a plea bargain. 5072, State of Texas versus David Michael Lynn. Can I have parties announced for the record for the state
Andrew Harris, Sadelman.
defense?
James Seeloff.
And are you Mr. Lynn?
yes, ma'am.
All right, you entered a plea of guilty on June 27th. And according to the plea bargain agreement, punishment is to be assessed at a cap of 14 months in the state jail facility. The state opposes your application. Have both parties had a chance to review the PSI report? State
No, Your Honor.
defense?
Yes, I have.
All right, any objections?
No objections.
All right,
Although he does say that he can live with his parents as opposed to being homeless.
okay.
Is that correct?
Yes.
All right, so the state is opposed to your application. Any witnesses defense?
At this point, something important is happening behind the scenes that viewers may not immediately catch. When Judge Boyd notes that the state is opposed to the defendant's application, she's referring to his request for community supervision or probation, something that is not guaranteed, especially in a case like this. When the state openly opposes probation, it signals that prosecutors believe the defendant either poses a risk, has a history of noncompliance, or simply hasn't shown the stability needed for supervision. Notice how the defense tries to shift focus quickly towards sympathy, emphasizing homelessness, family caretaking, and a desire for reform. But here's the real question for you watching. Does a difficult life circumstance excuse a repeated history of ignoring court orders? Drop your thoughts below. Would you consider probation here, or do you think the state is right in opposing it?
No, Your Honor.
State, do you have any witnesses?
No, Your Honor.
All right, the court will hear argument.
Your Honor, my client has never been on felony probation, and he's never had the theft course. And I asked the court to take a look at the offense itself and what was stolen. He was homeless at the time, and currently he says that he can live with his parents. And I asked the court respectfully to consider probation
All right,
in
and,
this circumstance. Do you have anything, David?
Well, yeah.
oh, just 1 second.
All right.
Counsel, could you have another trial court certification filled out for me, please?
Another one?
Yes,
Okay.
it is on the box. Because this one is dated June 27th, and I think it's because the court thought that we were proceeding with sentencing at that time. And then after you sign that, the court will hear testimony from you, Mr. Lynn.
All right.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
David Lynn.
All right, counsel, would you wish for your client just to talk to the court, or do you have questions?
No, I would like my client to address the court.
Yeah, I'm just living in my parents' house. I'll be taking care of them. My mom has dementia and my dad can barely walk. So I'm kind of like their caretaker.
All right, when people are on probation in this court, I don't allow them to be home healthcare
Oh,
provider.
no, I'm not getting paid for it. I go over there and help them out.
Okay.
Yes.
Why were you not doing this before you picked up these new cases?
This moment is subtle but critical. Judge Boyd is testing the credibility of the defendant's claims. When someone suddenly states that they're acting as a caretaker, especially when seeking probation, judges often look for consistency. If the defendant truly had a stable home and genuine caretaking responsibilities before being arrested, it would usually appear in earlier reports or be mentioned sooner. By asking, "Why were you not doing this before you picked up these new cases?" Judge Boyd is probing whether this is a genuine lifestyle change or simply a last-minute attempt to gain sympathy. These are the types of discrepancies that can make or break a probation request. What do you think? Genuine shift or convenient timing?
I've been going over there.
Mhm.
Yes, ma'am.
All right, so here's the court's concern. Looking at your criminal history, you have a criminal trespass. You were placed on deferred adjudication. The motion was withdrawn after a motion to revoke was filed and the case was dismissed. Then you had a theft case in 1995. You were granted 6 months probation. A motion to revoke was filed, then withdrawn, case was closed. In 1996, you had a driving while intoxicated case. You were given 6 months probation. A motion to revoke was filed. Probation was revoked. You were sentenced to 30 days in the Bexar County Jail. Then in 1997, you had assault, bodily injury, married. You were given deferred adjudication. A motion to adjudicate guilt was filed. You were revoked, sentenced to 6 months. In 1997, you had a driving while license suspended. Your probation was revoked. You were sentenced to 52 days in the Bexar County Jail. And then also in 1997, you had another driving while license suspended, 6 months in the Bexar County Jail. November 1997, driving while license suspended, 6 months in the Bexar County Jail. July 1999, driving while license invalid, enhanced. You were given probation for a year. Motion to revoke was filed. You were sentenced to 6 months in the Bexar County Jail. 2003, you had a theft, $5,500. You were sentenced to 90 days in the Bexar County Jail. 2006, you had a driving while license invalid. You were sentenced to 30 days in the Bexar County Jail. 2006, you had a theft, $50 to $500. You were sentenced to 45 days in the Bexar County Jail. 2006, you had a driving while license invalid, enhanced. You were sentenced to 30 days in the Bexar County Jail. 2007, you have a driving while license invalid. You were sentenced to 30 days in the Bexar County Jail. 2007, you had a criminal trespass to habitation or shelter. You were sentenced to 75 days in the Bexar County Jail. 2023, you had a criminal trespass to private property. You were sentenced to 26 days in the Bexar County Jail. 2007, you had a theft under $1,500 enhanced. You were sentenced to 6 months in the state jail facility. 2008, you had a theft under $1,500 enhanced. And a motion to revoke was filed, and you were continued on probation. And then you were revoked and sentenced to 6 months in the state jail facility. 2010, you had a theft, $1,500 enhanced. You were sentenced to 8 months in the state jail facility. 2012, you had a theft under $1,500 enhanced. You were sentenced to 10 months in the state jail facility. 2013, you had a theft under $1,500 enhanced. You were sentenced to 12 months in the state jail facility. 2013, you had a theft under $1,500 enhanced. That was dismissed. You were convicted of another offense instead of that. 2014, you had a theft under $1,500 enhanced. You were sentenced to 4 months in the state jail facility and given a judgment satisfied under 1244. 2015, you had a theft under $1,500 enhanced. You were sentenced to 12 months in the state jail facility. August 2015, you had a theft under $1,500 enhanced. That was dismissed. You were convicted of another offense. 2023, you had a theft under $2,500 enhanced. You were convicted of another offense. And then now we have your current offense. Then out of county in Guadalupe County, you have a theft of property. You were sentenced to 60 days. You had a driving while license invalid. You were sentenced to 127 days in New Braunfels. Then in 2007, you had a reckless driving. You were sentenced to 20 days. Then in Travis County, you had a theft, $1,500, 2 or more previous convictions, and you were sentenced to 6 months in the state jail facility. So the question becomes, why do you not stop stealing?
Because I had a gambling problem.
This right here, this is the turning point of the entire hearing. After Judge Boyd spent several minutes reading nearly 3 decades of theft, trespassing, probation violations, revoked sentences, and repeat offenses, she finally asked the question on everyone's mind, why does it never stop? And his answer, I had a gambling problem. This is where Judge Boyd's body language shifts. A gambling addiction can certainly drive theft-related behavior, but courts also look at accountability, treatment history, and whether a defendant has ever taken steps to address the root issue. In David's case, Judge Boyd sees a pattern, dozens of chances, every form of probation imaginable, and yet the same outcome every time. New charges, new violations, new revocations. For viewers, do you think this explanation changes anything? Or is Judge Boyd justified in doubting whether probation would work after so many failed attempts?
All right. Is there anything else?
That's it.
All right. The court is going to find you guilty. The court will deny your application. The court will sentence you to 14 months in the state jail facility. Give you credit for any time served.
Thank you, Your Honor.
Thank you. Did you review the document
Ma'am,
entitled
hang on.
Trial Court Certification of Defendant's
Ma'am,
Rights to
we're-
Appeal with your attorney? Did you understand it?
When me and him were on
Because
the,
this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not
I
have the
told
court's
my attorney I
permission to
wanted to
appeal.
fire him.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Good luck to you.
Ma'am,
And there it is. After weighing the PSI, the defendant's testimony, in a criminal timeline longer than many careers, Judge Boyd denies the application for probation and hands down a 14-month state jail sentence, exactly in line with the plea agreement cap. Her message is clear. After decades of revoked probations, repeated thefts, and unaddressed addiction issues, another chance simply isn't supported by the history. Judge Boyd also reminds him of his right to appeal, his firearm restrictions, and the consequences that follow a felony conviction, closing the hearing with her signature firm, no-nonsense tone. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Your engagement helps us bring you even more real cases, real rulings, and real-time legal analysis.